What's up, good people? Let me know that you can hear me in the chat by typing either Justice for Dre or Day One. Justice for Dre, which you can't see because I got the green screen up, but Justice for Dre, got my shirt on today, or Day One. It has finally arrived. We are now moving into our reenactment of the USA versus James Timothy Norman trial. We lived it in real life a year ago, and now we finally have the transcripts. And I'm not only going to be giving you recaps based on my notes, but we actually have the transcripts verbatim of what occurred on each day of the trial. So this is going to be epic. Welcome to everyone on all of my multiple platforms. We are now simulcasting on Facebook. Hello, my Facebook people, as well as Instagram. We have that new setup and it is working as of today. Third time's a charm because I've been trying to do it for 2 old lives. Well, this is a third live. Yesterday, had it all set up, forgot to hit the goddamn button, didn't realize until I ended the live. I was like, Lord, I forgot to hit the live for my Instagram people. So thank you to all of you who are watching. Hit that like, follow me, whatever. Every platform's got its own thing. If you're on YouTube, subscribe and hit that like button on the video. If you're over there on Facebook, hit that like button, follow me. If you're on Instagram, just follow me if you're not already following me. But tonight we're going to be doing the live transcript reading. Thank you to the 93% of you who have liked this video already. I greatly appreciate you. And tonight we're going to start with day one of the transcripts and have a poll question that I'm adding in here. The only people that can see this poll question is those of you who are watching from YouTube. So if everybody else is wondering, like, why I can't vote, you can vote in the comments. Vote in the comments or in your chat. But the poll question I just put out there for those of you who cannot read it is, do you want to hear the jury selection part of the transcript as well? So that's day one. I'm asking a question, although I already got the answer. Thank you to everyone who's let me know that you can hear me in the chat. We got his MJ, Misty Blue, Vicky, Alice, Nicole, Precious, Karen, Chanel, Don, and everyone else who is letting me know that you can hear me. I greatly, greatly, greatly appreciate that. Also, just checking. Well, I'm going to wait on that part of it. But just for those of you who are not familiar, I have a tie to the case because I was actually there at the Eagleston Federal Courthouse in St. Louis, Missouri, where the Tim Norman trial was held. And I was actually there with a couple other notable, it's a little smaller on the screen now, but a couple other notable YouTubers. We have Chronicles Speaks, who is there in the plum color, purplish blouse. And then we have JSO Extra, her channel is Today's Celebrity News. She'll be back. She's on a little bit of a YouTube hiatus, but she'll be back. Still subscribe. But anyway, myself and those ladies were there through the trial. Chronicle Speaks came the second week of the trial. JSO Extra and I were there the first and second week. And we came to you guys with videos with our first hand accounts. And so now what you'll have is my first hand account. This ain't no guesstimation. This ain't no I heard somebody say, I thought they might have said, I saw it on the news. Nope, I was there. I saw it with my own eyes. And now we get to add in the transcripts. So for tonight and the foreseeable future, we'll be going live for our reenactment of the Tim Norman trial transcripts with my enhanced account in the real world sense. It's, I think it's over, I don't forget, y'all. It's not, I think it's 9 parts to this. It was like 9 days, and each one has like well over 100 and something pages. I forgot. And in total, I think it's well over 1,000 pages. So we'll see how long it takes us to get through it. We have some some of our volunteers tonight who are going to be assisting me with reading. And as I was pulling their parts together and sending them information, I realized as I was actually really scanning through it, like putting the show together, I was like, ain't no way we even getting through day one today. It's not happening. We may get through a quarter of it or half of it, maybe, but we'll see. We're going to play it by ear. So we'll be doing this for a little while, a week, or I'm thinking 2 to 3 weeks, 2 to 2.5 weeks, 3 weeks, something like that. So on today's agenda, well, first, let me close out this poll because there was another thing I wanted to ask y'all before I move too far. Do you want to hear the jury selection transcripts as well? 75% of you say yes. 25% of you say no. We are going to do it because it is a large piece. And what it actually does is help bring context. I know some of y'all just want the junk food version of stuff. Y'all just want to get to the meat and I didn't do it. And my name is Terica. Y'all just want to get to all that, but you need the jury selection part to start to put all those pieces together to see how we ended up where we ended up. So we're going to get to that stuff. We will, but we got to start at the beginning. Y'all know I don't like to hop around and just be throwing stuff together. I like to do things in decency and in order and in chronological order. That was a rhyme. I ain't even tried. But next poll question I have is, have you watched my Tim Norman M for Hire plot timeline video on YouTube for this case? And I did that video back in February of 2023, where I literally went to, and this was during the trial period. This was like after one of the sentencing hearings or something. I was there a couple days. I basically spent almost 2 days driving around the St. Louis area to every landmark, every location associated with this case. Everything from Tim's apartment to the Bottoms Up Club where Terica worked. You name it, I was there. And just interested in how many of you have actually seen it. Look like 90-something% of y'all. I'm surprised with that. So what I'm doing is putting it in the chat here on the YouTube side. I think you might see it. No, let me put it here because I think if I put it over here on this other chat, you'll see it on Facebook as well. So on Facebook and YouTube, I'm putting the link to that video in the chat so you can take a look at it if you haven't seen it. And then also the other video that is more recent that I have out related to this case is the part 2 of the Michelle Griggs interview that I did. And I'm wondering how many of you have seen this. Let me put this poll question out there and then we're moving into the other parts of this. Got a lot of poll questions back to back. Trying to take the poll so y'all and see where we at. What's going on, Trey? See Money Boy Trey in the chat. So have you watched part 2 of my interview with Michelle Griggs? I asked that because part 1 has well over 100,000 plus views. Part 2 has like 40-something thousand views, which tells me that most of y'all haven't seen it. And it could be because you don't know it's out there. So here's I keep doing that. Here's the link. I'm gonna put it over here for Facebook and YouTube. The link where you can actually take a look at that video after you're done watching this recap. If you have not seen it, it is really good. And I'm also working on the video for the interview that I did with Andre's siblings as well. All of his siblings, all 5 of his siblings, putting that together. That'll be out in the very near future. So the executive people on Patreon have been walking through some of the editing with me. So we are working on it. It's coming. It's coming. So on today's agenda, we will be doing going over day 1 of the U.S. versus James Timothy Norman trial, which basically today will consist primarily of Judge Ross setting the ground rules for the trial, catching us up on some of the things that were occurring leading up to the trial. So motions that were made, meetings, all of those sort of things. There'll be some discussion of those sort of things. And then at the end of day 1, the first person to testify was Michelle Griggs. So we ended the day with them adding, with having Michelle Griggs testify. We will not get to that today, I already know, because of how much we have to read to get to that point. But as I said, earlier I was debating about skipping over the jury part, but as I was going through it, I'm like, yeah, we need this too. We need this too. So tonight, I want to introduce and thank my actors, for lack of a better word, my cast for tonight. We have Precious G, who is one of our moderators. I got to see how this is going to work out with us on the screen like that. Hold on, let me take some of this down. I'm going to see how this is going to all work out. But we got Precious G, who is one of our loyal VIPA members and moderators. We have Carolyn Chambers, who is one of our other loyal VIPA. And we have Robert, who is one of our loyal VIPA members' husbands. And I think he's also a part of our VIPA community. So welcome to everyone. And what we're going to get into. Also, if any of you are interested in reading, because again, now we're looking at maybe 2 to 3 weeks of this. You can hit me up on our VIP text community. I'm going to put that scrolling across the bottom of the screen for a moment. It is 312-847-2346. If you are interested in possibly reading. So I'm going to set the scene and then we're going to move into the transcripts. So on the first day of the trial, that was on September the 6th of 2022. So we arrived at the courthouse and we found out that we would not be allowed to go into the main courtroom that morning because they were doing jury selection, which was fine. We could actually sit in on jury selection. The problem was they had 59, I think it was 59 or 62 jurors that they were interviewing. And that took up all the space in the entire courtroom. This was different from what the staff at the courthouse were telling us, that wasn't the norm, that usually it would only be maybe 20 something, like would be a big case of jurors. And then that meant the media and the public could also be sitting in there during jury selection. So because of the lack of space, we had to go into overflow, which was basically another courtroom across the hall. And we just sat there waiting for them to finish with the jury selection. However, because for the media, they allowed us to go in rotation. So they would allow, I think they were allowing 2 or 3 of us in at a time. And what I can't remember is the time frame that they will allow us in there, but I feel like it was at least an hour or so that they would have us be able to go in there, and then you could come back at your leisure. You could come back. So that's what we were doing. And none of that was shared on video. So I should say this, none of this case is recorded. That's another reason why I was coming every night, giving the recap via notes, etc. Because there were no video. It was a federal case, so there are no video cameras or anything allowed, except for the courthouse's own webcam system, where they could broadcast to different rooms within the court building, which is what they did during the trial for us in the overflow area. But during jury selection, they did not do that. They didn't have it set up yet, I don't think. So I didn't make it into the main courtroom where they were doing jury selection until like that last 45 minutes or so, right before they wrapped it up. They were basically wrapping it up. So I caught a little bit of it, and that's the stuff I recapped for y'all at the time. And then they moved right into, well, we had a break, and then they moved into Michelle Griggs testifying. So we'll get to all that. Of course, we're doing the transcripts. So for the roles tonight, they are assigned as follow. For narration and commentary, that would be I, of course. For the judge, who is Judge Ross, that's going to be me, Vell B. For Miss Danis, also known as Angie Danis, who is the lead attorney for, oh, I got these pictures too. Hold on. Got too much on the screen. So this is Judge Ross. I'm going to be playing Judge Ross as well as the narrator and commentator. Then we have Angie Danis, who was the lead attorney for the U.S. Attorney's Office. And then we have Gwendolyn Carroll. I don't have a better picture of her, but this is the two of them together standing behind their boss. This was during the press conference after Tim was convicted. And so we have Gwen Carroll, who will be played by, I'm sorry, I skipped it. Angie Danis will be played by Precious G. Gwen Carroll tonight will be played by Carol.
That's me.
Right, that's Precious. And our Carol. And
That'd be me.
Gloria Rodriguez, who was Tim's, it was his primary attorney, but I think she didn't try cases or she just wasn't that good at it. Well, I could attest that she wasn't that good at it. I saw her with my own eyes. So she was the one who Tim hired, but Michael Leonard led the trial. He was like the lead attorney during the trial. So when you hear Miss Rodriguez, that's role is also going to be done by our Carol. And then we have Michael Leonard. Where's Michael Leonard's picture? Oh, here it is. Michael Leonard, who is Tim's attorney, the lead attorney during the trial. So you're going to hear a lot of him. He is going to be played by Robert, who is with us this evening. And then defendant James Timothy, I didn't do it, Norman, will be played by myself. So y'all already know what that criminal looks like. So, and then if we get to the part where the jury selection happens, there's, like I told y'all, they had it was at least 58, 59 jurors. And we're going to pick and choose which ones we're going to actually cover. Some of them just saying yes or no. Some of them giving a little bit of their business, spilling a little tea. So we're going to read those parts, but the other parts we'll skip. So we'll all be kind of switching off with those roles if we get to them this evening. So with that, it is time to get into the transcripts. I know that was a long way around. We got 18-minute intro, but hey, got to do the housekeeping. So we're starting the case. It started at, go to my first page, 9:02 a.m. on September 22nd. The courtroom is called to order by Judge Ross. Judge Ross states, "We are here on record in the case of the United States versus James Timothy Norman. It is for case number," and he gives the case number, "and we are here in the courtroom outside of hearing of the jury." So when they say, and we're going to hear this a lot as we continue to read through this, outside of the hearing of the jury means that the jury is not currently in the courtroom. So that means they can't hear and they cannot see what is happening in that moment. So he says, "We are here in the courtroom outside the hearing of the jury. The case is set to proceed to trial here today. Over the weekend and yesterday, there were some additional motions that were filed. There was the defendant's 8th motion in limine, the defendant's 9th motion in limine, and the defendant's motion to dismiss the indictment." So what this means in layman's terms, I'm going to break all this down as we go. Tim was up to his 8th motion of trying to throw a wrench in this. They basically, and that's why he hired Michael Leonard too, as well, because his entire job the whole time was to basically pull tricks and stunts so that this could be a mistrial of some sort, or they would just dismiss it. So even up until the weekend before, he was still pulling tricks and stunts. So Judge Ross says, "I want to take the defendant's take up the defendant's 8th motion in limine. It is to exclude the testimony of Michelle Griggs," or Miss Griggs here they have here. "Again, the parties have briefed this, and it relates to the defendant's 9th motion in limine, which is to limit the testimony if Miss Griggs is allowed to testify. In any event, I have an opportunity to review the motions. The court doesn't believe that there is prejudice to the defendant by allowing Ms. Griggs to testify. As I understand it, the government is not eliciting the testimony that is set out in the 9th motion in limine. I don't know whether or not there is any other record that you want to make with regard to that, but it would be in the court's intent to deny the 8th motion in limine to exclude Miss Griggs altogether. So they know that Miss Griggs, Michelle Griggs, Andre's mom, for those of you who don't know, was scheduled to testify. Well, he like, she can't testify. She know me in real life. She gonna say too much. So they, first of all, he's like, no, we don't want her testifying at all. No. And the court is like, and then they like, well, if y'all gonna allow it, then she can't say this, she can't say that, she can't attest to this, she can't attest to that. So they gave a list, and we don't know what it is because they have to keep that stuff from the public because they don't want the jury getting wind of it and all that. So I don't know exactly what he didn't want her attesting to, but they did win that part where the judge and the prosecution agreed. Oh, it's fine. You don't want her to mention that? You don't want her to talk about that? That's fine because we got still 40,000 pieces of evidence on you. No problem. So he says, Judge Ross goes on to say, as I have indicated, I don't believe that there is prejudice as it relates to disclosing Miss Griggs. So basically he's saying, I don't see a problem with identifying and having, letting people know who Miss Griggs is and that she was Andre's mom. That's no problem. I don't see the issue with that. He goes on to say, and the government is agreeing to the court granting the 9th motion in limine. Is that correct? Miss Danis, Miss Carroll? That's y'all cue. Who's Miss Danis?
That's correct, Your Honor.
we still learning, y'all.
I said that's correct, Your Honor.
No, I'm saying we must didn't hear your first time.
I said,
but we're practicing in front of y'all too. And any other record you want to make regards to Miss Griggs?
No, Judge. I think it's all set forth in our papers for both motions.
Okay, again, those are interlocutorial orders. If the evidence should cause me to change my ruling on that, approach the sidebar and I'll take it up at the sidebar. So that means throughout the trial, there were times where the attorneys would say, can I get a sidebar? And that would mean that they would walk to the side of the judge and they would do the white noise, which would be basically, we would hear that in the court. They would play it over like pretty loud. They would be in the corner. We couldn't hear what they were saying, but we would hear that white noise. So Judge Ross goes on to say, that brings me to the defendants. I guess it is the 3rd motion to dismiss the indictment. It is based on the disclosure of Chris Carroll's statement that were disclosed on August 26th. Again, the defendants filed a motion. The government has filed a response to that motion. I have to say, I don't understand why the statement wasn't turned over earlier. I don't believe that it constitutes a Brady violation because I think defense counsel has the statements. So basically, Chris Carroll, for those of you who aren't as familiar, Chris Carroll was Tim's road dog from prison, from what I recall, if I'm recalling correctly. They became besties. Chris Carroll is also known as AKA White Boy Chris. He worked at Sweetie Pies, and he was also known to be the muscle for Tim, so to speak, if you know what I mean, in the streets. So Chris Carroll is being brought up, and there was a motion to dismiss Tim's indictment based on the disclosure of Chris Carroll's statements that were, and I don't even know what those disclosures were. I think that was something else that might have been private. But whatever Chris Carroll said, his attorney was trying to say it constituted the Brady violation. So basically, it would mess up Tim's case. But he's like, no, but you already had that information, so that ain't That ain't mess up nothing. So Judge Ross goes on to say, as I understand Mr. Carroll's role, he is an unindicted co-conspirator, at least at the government's theory of the case. He makes what defense counsel has characterized as exploratory statements that have been disclosed, were disclosed on August 26, which in the court's view, adequate time for the defense to use those statements to whatever extent they want to use them or believe that they are useful to the defense. If there is something else you want to tell me about Ms. Rodriguez, Mr. Leonard, I'll give you an opportunity to do that.
Well, the reason, Judge, we brought the motion is to protect the record on these issues. And in our mind, clearly, this is Brady material, not Giglio. It is certainly exculpatory, and it is part of a pattern of motions we have raised with this court, raising issues with the non-disclosure of Brady and Giglio material. I wanted to make sure that our record is fully protected with regard to this particular issue, which we think is Brady material. And otherwise, our position is set forth in our motion.
Okay. Anything else the government wants to tell me with regards to this motion? Ms. Carroll?
No, Your Honor.
Okay, again, I think it's unfortunate, in my view, that the statements weren't turned over prior to August 26th. I don't really understand the government's theory in not turning them over before that date. I think Mr. Carroll's role in this has been well known for some time. Basically, we know he a crook. No. He says, the exact statement, as I said, I don't understand why they weren't turned over, but I don't believe that it constitutes a Brady violation. They were turned over in more than adequate time for them to be used for whatever extent they could be used, or Mr. Carroll himself used as a witness for the defense. Under all the circumstances of the case and disclosure, the court is going to deny the motion to dismiss the indictment. So again, so that the record is clear, defendant's motion in limine number 8 to exclude Ms. Griggs is denied. Defendant's motion to dismiss the indictment is denied. Defense ninth motion in limine related to testimony of Ms. Griggs will be granted by agreement with the government. So again, whatever pieces they said with, you can't ask her this, she can't say this, they like, okay, fine, we're going to go with that. Judge Ross continues and says, there were a couple issues that the court brought up last week at the final pretrial conference with regards to some Q&A on witnesses and the agent's notes with regard to witness. Mr. Hill's drug use, and Mr. Hill is Travail, whatever. Travail Hill. So Travail Hill's drug use on the date of the offense. And as I understand it, the government the court had actually, he stuttered there. So the government has, the court actually directed that they be produced in camera for the court's review to make a determination of whether or not they should be turned over. But the government has turned those over. Is that correct?
That's correct, Your Honor.
Okay, all right. There is a 6th motion in limine that the court reserved ruling on. It related to, I believe, a jail call by Ms. Danis.
Between Tony Whitfield and Travail Hill, Your Honor.
Right. And I'm still a little bit
The
of
court,
a
right?
huh? I'm no, that's me. Right. I'm still a little bit of a loss
Yes,
to understand the government's theory on how that's admissible. I understand defense counsel's argument is that it is simply to a prior, simply a prior consistent statement. It is not a statement of furtherance of a conspiracy. So explain to me.
Your Honor, we believe it's in furtherance by way of updating another member of the conspiracy as what is going on or in the pleadings.
But at this point, Mr. Hill has been arrested.
No, not during the jail call. This is in 2 days after the homicide. He is speaking with his brother. He is about to go to receive payment from a third party for committing the homicide.
So the brother is in custody?
Correct.
So Mr. Whitfield is in custody. Mr. Hill calls him or a call is made. Again, so simply updating a member of conspiracy.
We believe in the case law we asserted supports that theory, Your Honor. Certainly, we understand if the court disagrees, we may later, and should the defense go down the road of impeaching his credibility, we may believe that we may be able to offer that as a prior consistent statement, dependent upon the cross-examination of Mr. Hill.
Okay, at least at this point, I'm going to grant the motion in limine. Defendant's sixth motion in limine as it relates to the statement. I think there were there were other statements as well. In any event, I'll grant the motion in limine as it relates to the statement. Again, if the evidence should cause me to reconsider, just approach the sidebar and I'll take it up at the sidebar.
Will do, Judge. Thank you.
Anything further with regards to the pending motion? There was also a motion to file a sealed supplement to a motion. We didn't take that up at the final pretrial conference. I don't even know what that relates to.
Judge, at the moment, I don't recall. It was basically, I'm sorry, Judge. It was the underlying materials of the motion that dealt with Mr. Hill. Now, as you recall, I think it is on August the 30th, they produced those 12 pages of documents, which related to Hill being arrested. And the documents talk about federal narcotics law violations, and they also make reference to Mr. Hill's use of meth and the seizure from him of meth and scales. Those are the underlying documents that were the subject of our motion. We think it is important for record purposes for those to be in the record. They don't have to be doctored publicly. They are police reports and have personal identification, which would make it inappropriate for the public to see them because it talks about other folks and their addresses. We would like for those to be filled on the docket under seal. So now the record is clear what we are arguing about when we pose those motions to your honor.
Any objections by the government?
Your Honor.
No objection, Your Honor.
I'll grant the motion to file the supplement under seal. As a part of your motion to dismiss, you ask that the recording be made part of the record. Discovery generally is not made part of the record, so I'm going to deny the request. You have the recording. The government has the recording. For purpose of appeal, you have made your record. You have the recording. There is just no reason for it to be made part of the record.
Well, I understand, Judge, and thank you.
All right. Any other motions to take up at this time, Mr. Leonard, Miss Rodriguez?
Not at this time, Judge. Thank you.
On behalf of the government?
No, Your Honor.
Okay. Miss Danis, you have to listen to us on StreamYard. YouTube is seconds behind. So if you got the volume on over there, it's making you delayed from us.
Okay.
All right. And again, just for the record.
No, Your Honor, thank you.
Thank you. And again, just for the record, we have 59 panel members. So he's talking about the jurors at this point. We're going to bring them up. So this is all happening before the jury enters the courtroom. So again, for the record, we have 59 panel members. We are going to bring them up. We do have 4 chairs next to the back row of pews to my left that I think you can see back there. So that's panel members 56, 57, 58, and 59. So basically he's pointing out there's not enough space in the courtroom, so much so that they had to put chairs in the back of the courtroom. And it's a pretty big courtroom. It wasn't tiny. Remember, it is always left to right. I'm going to ask Mr. Burson to go down and get the jury list so that you can see them. I just want to make sure you are clear. I just ask that both sides get 2 copies of the list. You can use the list during jury selection. Once the juror is picked, we are going to get those back from you. And so we will go to get the jury list. You can have some time to look at it before we bring the panel members up for jury selection. So, okay. So while we wait, I don't know whether or not you have anything else, Mr. Leonard, Ms. Rodriguez, at this time.
Well, we don't, Judge. Thank you.
On behalf of the government?
Your Honor, I just want to ask for purposes of testimony. Do you prefer that when we have an expert testifying that we tender to the court, or as an expert, do you have a preference?
My preference is that you do not do that simply because you have either laid a sufficient foundation for them to give an opinion or not. And so that's my view of it.
Okay.
I do want to say a couple other quick things as I'm thinking about it. So Judge Ross is doing all of this as the jury is being collected from other parts of the building and getting ready to be brought in. So right now the jury's still not in there. He says, there is certain evidence that I anticipate you are going to present that requires an instruction from the court, such as a statement with a transcript. There is instruction to be read to the jury before transcripts is used. There's an instruction with regard to testimony of people who have pled guilty in the case who are testifying. So he's talking about Vell and Terrica. YL, he skipped out. We'll get to that. Says, I need you to tender an instruction to me in advance of that occurrence if you want me to read the instruction. Obviously, I'm going to try to make sure I identify that before it happens, but you know what evidence you are presenting. So I need you to make sure that you let me know before that occurs and that I have appropriate notice to have that instruction. So he's saying when those moments are coming, there are stipulations that both sides are going to want the jury to consider, to omit, to whatever, to have a certain frame of mind for. And he's saying, I need to stop right before that person testifies, read those instructions to the jury, but I need your help with, for one, giving me those instructions, but also letting me know ahead of time when it's coming up so I don't get caught off guard and forget, et cetera, et cetera. Miss Danis. I think you're still on the delay, Miss Danis.
No, it's not that. I scrolled down too quick on the
okay.
on my script. I'm
no
sorry.
problem.
I'm sorry. I was trying to see when we said juries. I was making sure I didn't miss my jury selection.
Oh.
I'm sorry. Give me 1 second. My bad, y'all.
Line 23 on page 9.
I'm sorry.
You're fine.
Line 23. Okay. We will do that, Your Honor.
Okay, all right. I guess I should also note for the record that there was an agreement about a statement to be read to the jury. And I had a couple questions about the agreement. I have to say to you, I have never asked questions usually about an agreement, but I need to in this instance.
Sure, Your Honor.
One is I want to insert the date of the murder for Andre Montgomery. Again, I'm inclined to insert the location where it occurred, just because if people somehow on the panel live in the area and knew about it by word of mouth, I want them to be able to answer that for me. So as I understand it, the murder occurred on March 14th, 2016 in the 3800 block of Natural Bridge.
3900 block.
Okay, 3900 blocks. So it would be my intent in the statement to insert that. Any objections to that, Mr. Leonard?
No, Judge.
Any objection?
No objection, Your Honor. That's appropriate.
You had reference to broadcast on the to broadcast on the Oprah Winfrey Network. I mean, do you believe that's important information to give? I just didn't understand.
Yeah. That's where the show ran. Instead of being on CBS or NBC, it ran exclusively on that network. I don't know that it matters, however. I don't have a strong feeling about whether or not it's included in that or not.
I was just a little concerned almost that it limits where they might believe it is.
Yeah, because they could have seen it online too, Judge. We have no problem striking that.
Okay, all right. We are talking about housekeeping matters. There was a motion in limine that was filed as it relates to this disclosure of defense expert. I had indicated, Mr. Leonard, Ms. Rodriguez, that you could make an offer of proof. Just let me know when you want to make that offer of proof. We can do it tomorrow morning. We can do it later today, whenever you want to do that.
Would you be okay, Judge? Can we just submit that in writing tonight? Is that appropriate? Or would you want us to do it verbally?
Honestly, it's your offer of proof. However you want to do it is okay with me.
Yeah. I'll just file something, Judge, tonight laying out what our offer of proof is. It will be very brief, Judge.
All right, that's fine.
I appreciate that.
Ms. Carroll?
No objection, Your Honor, to that.
Oh, we couldn't hear you. But Ms. Carroll, Your Honor, this is Ms. Carroll. Your Honor, the only other was
Your Honor.
Go ahead.
Your Honor, the only other was the issue regarding the forfeiture decision.
I'm sorry. I had that on my list of things to cover.
Yeah. Unfortunately, since we didn't see Mr. Norman live, can I have a moment to explain it?
Sure.
I know what our position is. I just want to verify that.
That's fine. So on the side, they held a discussion off the record. Mr. Leonard, attorney Michael Leonard, was conferring with Tim Norman.
Judge, my screen just went out. What number were we on?
That's number 12. If you need a moment, I'll read his part. So Mr. Leonard then says, Your Honor, I had confirmed with Mr. Norman that we wouldn't be seeking a jury determination on a forfeiture. We would leave that to the court. So basically what they're saying is in that moment, there was a question about Tim, if convicted, would have to forfeit over his possessions, all that kind of stuff. So there was a question of whether they wanted to leave that up to the jury or whether or not he wanted the judge to decide. They ended up leaving it up to the court, the judge, and the judge took care of that. That stuff is in the motions. After he got convicted, yes, they snatched his ish, if you were wondering. Yep, they took stuff. We'll read that once we get done with this. I'll pull that for y'all. I think I even have it, actually.
What number are you on? What number are you on? What page, Mr.
So we're on page 12 now, number 15. And this is Judge Ross. So Judge Ross.
Okay, I'm back on track.
Okay, good. Okay, Judge Ross goes on to say, okay, Mr. Norman, I need to ask you this. It is your right to have the forfeiture allegation heard by the jury, or you can waive that right and agree to have it submitted to the court based on the evidence that is produced during the course of the trial. Mr. Leonard has indicated to the court that you are going to waive your right to have the matter determined by the jury and agree to have it heard by the court. Is that in fact correct? This Tim. Yes, sir. That's correct. And you have enough time to talk to your attorney. He has answered all of your questions about the issue. Yes, sir. The court, this is Judge Ross. You are doing that freely and voluntarily. Is that correct? Yes, sir. Again, do you understand? Although he can advise you about that, it is ultimately your decision. And this is, in fact, your decision. Yes, sir. And any question about any of that? No, sir. Okay, Mr. Leonard, any other record you want to make with regard to the forfeiture allegation?
No, Your Honor. Thank you.
Any other record the government wants to make in regard to the forfeiture allegation?
No, Your Honor. Okay, Judge, I have another question. Do you prefer us to refer to the jury by their number or by their name? Do you have a preference?
No, I don't have a preference.
Thank you, Judge.
One other minor housekeeping matter. I don't know whether or not to either side intends to try to use an exhibit during the opening statement. But if you do, you need to consent. You need the consent of opposing counsel because they do not have technically been admitted into evidence. So again, I don't know whether or not you intend to do that or you intend not to.
We do have some slides, Your Honor. We will email them right now before we share them.
Well, you can't show them unless both sides agree.
Understood.
We're not going to use anything.
Okay.
I'm sorry, Your Honor. What did she say?
She said that we're not planning on using exhibits. She asked a lot of questions like that throughout, y'all. It's like, are you here with us?
Oh, okay, thank you.
But again, they have not been admitted in evidence. So you need to have consent of the opposing counsel. Ms. Rodriguez.
Thank you, Judge.
So at 9:55 a.m., the jury panel was seated.
Okay.
Okay, the jury panel was seated and the examination of the jury commenced from there. So a little bit of a break. Let me give y'all a little bit of a quick commercial break. Take a swig of water. This is literally like only a minute though. Where is this? All right, I'm back. Letting the camera get focused too. Hello, camera. All right, there we go. All right, so we're going to bring our team back up. Okay, looks like we may have lost Precious, but hopefully she'll be back. Okay, so now we have the jury. The jury has come in. Now Judge Ross is addressing the jury. Good morning, ladies and gentlemen. I'm Judge John Ross. I am a United States District Judge here for the Eastern District of Missouri. On behalf of everyone here at the courthouse, everyone here in the courtroom, I want to welcome you here this morning. I want to quickly tell you about our COVID protocols. Obviously, over the last couple of years, we have had to adjust our protocols on different occasions. We have followed the CDC guidelines, the guidelines for health professionals, and we are very fortunate. And we have tried a number of cases over the last couple of years and have had no problems with anyone getting sick. So he goes into explaining what exactly the COVID protocols were. They were very loose during the time of this trial, just from my personal experience. It was up to you if you wanted to wear a mask or not. 99% of the people did not wear masks during this trial. Now, it seemed like the only people that were wearing masks was the criminals. Like Vell wore a mask, and I feel like, no, Tim didn't really wear a mask. Terica had a mask on at times. So moving on, he goes on, he gives, all of that. Then he says, the case that you have been called to here is to try a criminal case. It is titled as the United States versus James Timothy Norman. Mr. Norman is charged with three counts indictment with offenses of conspiracy to commit murder for hire. Count 2 charges him with murder for hire. Count 3 charges him with conspiracy to commit wire and mail fraud. Mr. Norman has pled not guilty to those charges. Thus, there are issues of fact for a jury to decide. A trial of any case begins with the selection of a jury of fair and impartial people. In order to obtain such a jury, all of you have been summoned as a prospective juror. From your number, a jury will be selected to hear and decide this case. It is necessary that you be asked various questions. Your answers will assist the court in determining whether it should excuse you from service in the case and will assist the attorneys in making their selections for those who will sit and hear the case. Thus, the questions that will be asked of you are not meant to pry into your personal affairs. Rather, they are a necessary part of the process of selecting a jury. Please listen carefully to all of the questions. Take your time in answering the questions. Some of the questions may require you to recall matters and experiences during your entire lifetime. Therefore, search your memory before answering. If you don't understand the question, please raise your hand and say so. If later on during the examination you remember something that you failed to answer before or would affect or modify in an answer that you gave before, please raise your hand and you will be asked about it. Your answers must not only be truthful, but they must be full and complete. If your answers to any of these questions involve matters that are personal or private, you may so indicate. And I'll give you an opportunity to state the answer up here at a sidebar at the bench. So you still got to tell your business is what he's saying. You still got to tell me. Again, we try to keep those conferences to a bare minimum. But if there is something that is just so personal that you are uncomfortable answering in front of an entire panel, please let me know. I do want to tell you, it is very important that you speak loudly and clearly, because not only does the court need to hear you, But the court reporter, who has to take down everything that is said in the courtroom, she can't take down something she can't hear. So that's the person who typed up all this stuff that we read now. He's like, talk loud and clear enough so she can hear this. She also can't take down a nod or a head shake. So you can't just shake your head or nod. You have to answer out loud, yes or no, affirmatively. I'm also asking those of you, particularly those in the pews, to do something that may seem a little bit uncomfortable, but it will help us. And that is, I'm going to ask you to stand if your jury number and name, and give your jury number and name before you answer a question or ask a question. So he's talking to the parts of the jury who ended up having to sit out in the audience area because it's, I don't know how many rows it was. I don't know, about 5, 6, 7 rows, something like that. So he's like, I can't see all y'all in the back. I'm gonna need y'all to stand up and talk because I won't be able to tell who talking or where the sound is coming from. Because again, the courtroom was pretty decent size. Okay, so I hope you would bear with me as we go through this. It is important that we know who is speaking and what you are saying. If you do have a mask on, I am going to ask that you lower your mask when you are speaking, again, so we can hear you. The trial of the lawsuit involves a considerable time and effort. The parties are entitled to have their rights finally determined. The failure on your part to fully and truthfully answer questions during this stage of the trial could force the parties to have to retry the lawsuit at a future date. Because this is such an important part of the trial, you are required to be sworn before questions are asked of you. If you would please raise your hand, please raise now and be sworn to answer. So then Judge Ross, he says, ladies and gentlemen, I have the initial instructions to read to you before I begin to ask questions. Please listen carefully to this. Members of the jury panel, if you have a cell phone, smartphone, iPhone, Android device, or any other wireless communication with you, please take it out now and turn it off. Do not turn it to vibrate or silent. Please power it down. I'll take a moment just to let you do that if you have not previously done it. So with this, when it came to the devices and all of that, they were really big on they were vigilant on when we would walk in, they want you to show them your phone turned off. If they saw you looking down too hard, like in the audience and anything, you would have the marshals come up and be like, what you doing? What you up to over there? Like all that. So yes, that was a big rule. No devices, electronic devices were allowed. He goes on to say, I'll tell you as that being done during your jury selection. I'll tell you as that is being done during your jury selection, you must leave those devices off. When you're outside the courtroom, break rooms, or recesses or adjournment of the court, obviously we understand you want to check your phone or your devices. But while you are here in the courtroom, we ask that you keep those devices off so your attention is entirely on what is going on here in the courtroom. If you are selected as a juror in the case, you cannot talk about the case or communicate with anyone else about the case until I tell you that such discussions are allowed. So during the trial, the complete time of the trial, they were not allowed to talk to anyone, of course, interview with anyone. However, on that last day, he did give them instructions that, hey, it's up to y'all. He said, I wouldn't advise it, but it's up to y'all if y'all want to talk to media and all of that. It looks like no one chose to, at least from what I saw. He goes on to say, you cannot even discuss the case with your fellow jurors until I tell you to begin deliberations at the end of the trial. When I say you cannot communicate with anyone about the trial in any way, this includes communications in writing, through email, via text messaging, on blogs, comments, posts, or by accessing any social media websites or apps such as Twitter, Facebook, Instagram, LinkedIn, YouTube, or any other apps that are popular or that you use. He goes on to say, similarly, you cannot post your own thoughts on any aspect of the trial. The point is that you must not access or allow any app or communication of any kind to expose you outside information or opinions, expose you to outside information or opinions about this case, or to expose others to your opinions about the case during the trial. Many of the tools you use to access email, social media, and internet display third-party notifications, pop-ups, or ads while you are using them. These communications may be intended to persuade you or your community on an issue and could influence your service as a juror in this case. For example, while accessing your email and social media or the internet through no fault of your own, you might see pop-ups containing information about the case or the matters, legal principles, individuals, or other entities involved in the case. This means that you will need to stay off of all social media platforms for the duration of the trial. These are only examples. The sole exception to this rule about communication will occur during your deliberations, when I will direct you to discuss the case with your other jurors. Throughout the trial and even during the deliberations, you also cannot conduct any type of independent or personal research or investigation regarding any matters related to this case. Therefore, you cannot use your cell phones, iPhones, notebooks, tablets, computers, or other devices to do any research or investigation regarding the case. The matters in the case and legal issues in the case, or the individuals or entities involved in the case. This includes accessing sites such as, and he goes through the sites again. He says you must also ignore any and all information about the case that you might see, any event or accidental, blah, blah, blah. So I ain't gonna keep repeating that, but he's basically saying, oh, here's another part. He goes to, I understand that you may want to tell your friends and family, close friends, and other people about your participation in this trial. Be like, oh, I'm about to convict Tim Norman. He says, so you can explain what you are required to do. You can explain when you are required to be in court. While you can tell them about these sort of logistical issues, you should warn them that you cannot speak about the details of the case, and they should not ask you about the case, tell you anything they know or think about it, or discuss the case in your presence. If you discuss the case with someone other than other jurors during deliberation, you may be influenced in your verdict by their opinions. That would not be fair to the parties, and it would result in a verdict that is not based on the evidence of the law. And we were debating about this during the trial, like, should this particular trial, these jurors have been sequestered? Like, part of us was thinking they should have been sequestered, but they weren't. They were allowed to go home every day. The parties have the right. Parties have a right to have this case decided only on the evidence they know about, and that has been presented here in court. If you do some research, investigation, or experiments that we don't know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. The parties are entitled to a fair trial rendered by impartial jury, and you must conduct yourselves so as to maintain integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties fair trial in accordance with the rules of this country, and you will have done an injustice. So he's saying it's very important that you abide by these rules. Failure to do so could result in the case having to be retried. It is also important that you discharge your duties without discrimination, meaning that bias regard to race, color, ethnicity, national origins, religion, gender identity, sexual orientation, disability, or economic circumstances of the defendant or any witness or other participants associated with this trial should not play a part in your exercise of your judgment throughout the trial. Let me see. Let me make sure. So he then goes on. He says, ladies and gentlemen, again, I'm going to be asking a number of questions. There are no right or wrong answers to these questions. If you are unsure of whether or not something is important or not important, please err on the side of telling us. As I indicate to you, it is important that you give full, complete, and truthful answers to my questions. So, okay, now we're getting into the actual questions for the jurors. And he starts with, I want to start out by asking about prior jury service, whether or not any of you have served on a jury before, not necessarily just the selection process, but actually served on a jury. So I'm going to start here in the jury box. So there were some of them who were sitting in the jury box. Any of you served on a jury previously? If I can see a raise of hands, Mr. Rose.
Yes, I have, sir.
Was it in the state court or federal court?
St. Louis City criminal case.
And were you the foreperson in the jury?
I was not.
Did the jury reach a verdict?
We did.
Anything about that experience that would affect your ability to be fair in this case?
No.
Thank you very much. I believe it was Miss Beckerly. Yes, ma'am.
Wait, was that me too?
No, that's a different person, Beckerly.
Oh, okay. I was like, wait a minute. I don't have that highlighted. Okay, I guess I'll do it.
Yeah, please.
Okay. Wait. Okay. Twice.
Civil case or criminal case?
One civil, one was criminal.
In the state court or federal court?
One was federal, one state.
And were you the foreperson for either jury?
No.
The federal case was the civil criminal. Was that civil or criminal?
Criminal.
And how long ago was that?
32 years ago.
It has been a long time.
I know. I got sequestered in Kansas City.
And I think I asked you, were you the foreperson of the jury or not?
No.
The jury reached a verdict. Did the jury reach a verdict in that case?
Yes.
Anything about those experiences that would affect your ability to be fair in this case?
No.
Thank you very much. And I thought there was another hand. Yes, sir.
Yes.
And is it Mr. Way? Mr. May?
Correct.
Yes, sir.
Yeah, I served in that state court in Clayton. I couldn't tell you how many years ago. I know it was over 20.
Civil case or criminal case?
Civil.
Okay, were you the foreperson of that jury?
I was not.
The jury reach a verdict?
Yes.
Anything about that experience that would affect your ability to be fair?
No, not at all.
Thank you very much. And I think there was another hand. Okay, I see no other hand. Let me go over here to the pews to my left. Anybody serve on the jury, either civil or criminal, in state court or federal? I see no hands. We are happy to have you here today. Let me go to the middle pews. Anybody serve on a jury? Let me go to the first row. Yes, ma'am. I think in the middle. Yes, if you don't mind standing up and giving your name and jury number.
Number 21.
I'm afraid you will really have to yell because I have a hard time hearing you. Is it Miss White?
Kimberly Dung.
I'm sorry. I apologize, Miss Dung. Yes, did you serve on a civil case or a criminal case?
Criminal.
In the state court or federal court?
State.
Were you the foreperson of the jury?
No.
Anything about that experience that would affect your ability to be fair in this case?
No.
And did the jury reach a verdict?
Yes.
Thank you very much. Thank you. And then there was another hand. Yes, sir. And it is Mr. Bond.
Was that B2?
No, I think our co-readers are muted. I don't know, but go ahead.
Okay.
Thank you. We gotta keep this train moving.
Okay. No.
I done lost my place. Okay.
I lost my place.
And did the jury reach a verdict? Wait a minute.
Yeah. I said no. Bond. No.
Okay, here we go. Here we go. So, yes, sir. Civil case or criminal case? State court or federal?
Civil and state.
Okay, were you the foreperson of the jury?
No.
Did the jury reach a verdict?
Yes.
Anything about that experience that would affect your ability for a fair case?
No.
Thank you very much. Yes, ma'am. I'm on the end, and it would be
Denise Sohing.
Yes, your jury number. Do you know?
36.
I'm sorry.
That's all right.
Was it civil or criminal?
2 civil cases and 1 criminal case.
And were they in state court or federal court?
State.
Were you the foreperson of any of those juries?
Oh, no, I was not.
Did the jury reach a verdict in those cases?
Yes.
Anything about those experiences that would affect your ability to be fair in this case?
No.
And thank you very much. And just so and if I'm mispronouncing anyone's name, I'll apologize in advance. But is it Miss Sohing?
Sohing.
Okay, Sohing. So, okay, I'll try to remember that. And then a hand in the back. Yes, sir. If you will just tell me your name and your jury number.
Juror 47, Nicholas Torrance.
Yes, sir.
It was a state criminal.
Were you the foreperson of the jury?
No.
Did the jury reach a verdict?
Yes.
Anything about that experience that would affect your ability to be fair in this case?
No.
Thank you very much. Anybody else in the middle pews? And I'm going to go to the pews here to my right. Anybody serving on jury? And again, I see no hands. When we have the 4 chairs here at the end of the pews to the left, and I don't know whether or not you are all answering as we were asking about the pews to the left, but anybody in the 4 chairs, it is 56, 57, 58, and 59. Yes, sir.
Brian Pennington.
Yes, sir.
Number 57.
And was it civil or criminal?
Criminal.
State or federal?
State.
Were you a foreperson of the jury?
No, sir.
Did the jury reach a verdict?
Yes.
Anything about that experience that would affect your ability to be fair and impartial in this case?
No.
Thank you very much, Mr. Pendleton. Again, anybody I missed? Okay, I'll take it by your silence and lack of hands that all of you have had an opportunity to answer. You will hear me use the phrase from time to time. The reason I do is because if there are no hands or response, the court reporter can take down silence, and so that there are some in the record to reflect that there's something in the record to reflect that there were no responses. I will say, I'll take it by your silence and lack of hands that none of you have response. I just want you to be aware of that. I want to talk about the length of the trial. In talking to the attorneys, we anticipate the trial is a little bit of a longer case. We expect that we won't finish until towards the end of next week or the end of the next week. So they were expecting this trial to last 2 to 3 weeks. And we were told that in the beginning. And I was like, Lord, please let it only be 2 weeks. 3 weeks, I wasn't gonna be able to do the third week. It was gonna be a problem. I had big plans. Says, and I believe all of you were notified about that at the time of the summons originally, when the summons originally went out. I want to tell you a little bit about our hours here in the courtroom and what the committee commitment involves. Generally, the court will be from 9 until 5 or 5:30 each day. We will take a mid-morning break around about 10 minutes to let you stretch your legs and get a drink of water. We will take a lunch break for an hour or an hour and 15 minutes or so. We'll take a mid-afternoon break for about 10 minutes to let you stretch your legs. Again, we anticipate we will go each day. We won't work on the weekends, so we will work Tuesday through Friday and Monday through Friday. So Tuesday through Friday, because this particular day was the Tuesday, and then the following week was the full week, technically, because I think we ended on Friday. I think the verdict came out on Friday. I may adjust the schedule if it looks like I need to do that so that we can finish up by the end of next week. But generally, that's the schedule that we're going to follow. Given the length of time and the schedule, understanding that you're going to be home each night, you are going to have breaks. You're going to have an opportunity to do hopefully what you need to do. But again, I understand it's a commitment. But what I want to ask you is that any unreasonable hardship for anyone, because if you have a medical condition or a sole caretaker of someone with a serious medical condition, such that, again, it would be an unreasonable hardship for you. So let me just start here in the jury box. Anybody have unreasonable hardships that they would want to bring to my attention? I see no hands. Going here to my left, anybody have any unreasonable hardships given to the length of the trial? Yes, sir. Will you stand up and give your name?
Juror number 30, Carrie Thesson.
Yes, sir.
My father was hospitalized over the weekend, and I was informed this morning that he has taken a turn for the worse. So I don't believe that I will be able to fully complete the process here.
Okay, obviously, we are very sorry about your father and understand those circumstances. I understand that you don't know what's going to happen, and that's essentially what you are telling me. Is that correct?
Yeah, that is correct.
Okay, and that would be on your mind if you were here in any event?
Yes, it would be.
All right. Again, if you want to tell, I want to tell you, ladies and gentlemen, when you give me that information, we will definitely take that into account. So I understand. Thank you very much, sir. And I remember this part. This is actually about the part where I came in. I think I came in right here because I remember this. And I was listening to the guy and I was like, I don't know. Precious gave an old solemn voice. His voice wasn't quite that solemn. I was like, what you just heard this morning? What? Because he just didn't have that. Precious gave a better acting job than he did. So I was like, that looked like you made that up just right now, right in the moment. But anyway, it might be true. And if it was, God bless him. And I hope his father's okay. But anyway, so Judge Ross goes on to say, anybody else in the pews here to my left? Okay. The pews here in the middle. Anybody have any unreasonable hardship that they want to bring to my attention? I see no hands. The pews to my right, I see no hands. The chairs. Okay, again, anybody have significant hardship that they want to bring to my attention? This is the time to do so. I see no hands. I want to introduce you to the people that you see at the council table. To my right, counsel for the United States, Miss Angie Danis and Miss Gwen Carroll. They are the assistant United States attorneys. Also at the table is Detective David Rudolph, who is the case agent in this case. Do any of you believe that you know any of the people that I just introduced you to, either personally or professionally? Anyone believe that they know them? Okay, let me know. Let me get you here. Yes, sir.
Juror number 29, Pete Burrito.
Okay, and Mr. Burrito, I know, I know that you were a police officer for a number of years. Is that correct?
Yes, sir, it is.
And you are presently a deputy sheriff for St. Louis County?
Yes, sir, I am.
Okay, and am I assuming you know somebody here at the council table? Can you just tell me who you know?
I know the officer.
Okay, Detective Rudolph or Officer Rudolph?
Yes, sir.
Okay, just given your background and history, do you believe that would affect your ability to be fair and impartial jury in this case?
No, sir, it wouldn't.
Okay, you were a police officer with Shrewsbury, is that right?
Yes, sir.
29 years?
29 years and 3 years with the city of Pine Lawn.
Okay, so you actually have 32 years in as a police officer. How long have you been with St. Louis County Sheriff's Department?
Going on 8 years.
You got a lot of pensions, don't you, y'all?
Mm-hmm.
Okay. All I'm doing is counting the change. Okay, all right. I thank you very much, Mr. Burrito. And are there any other hands? Yes, ma'am.
Juror number 55, Jamie Robertson, and I also know Detective Rudolph. My husband and him worked together.
Okay, I see that your husband was a city of St. Louis police officer?
Yes.
Okay, and has he worked with Detective Rudolph?
Yes, City of St. Louis police officer, also in the homicide division.
Okay, and one of the things that the jury will have to do, and I'm open, and I'm going to talk about this later, is determining the credibility and believability of witnesses. The fact that your husband has worked with Detective Rudolph, do you actually, have you talked to Detective Rudolph?
It's been a while, but yes.
Okay, the fact that the juror has to determine credibility just based on your relationship, your husband's relationship, do you believe that could affect your ability to weigh in his testimony as you would any other witness, just your knowledge of him?
I think that I can be a fair juror. Yes.
Okay, so you believe that you can set aside the fact that your husband has worked with him. Obviously, this is, well, okay. So again, you are telling me that you can set aside, weigh his credibility and believability just as you would any other witness?
Yes, sir.
Okay, thank you very much. And anybody else in the pews to my left? Okay. The pews in the middle, anybody know anything of the people that I have introduced here at the council table to my right? And I see no other hands. And the pews to my far right, And the chairs in the back. And I see no hands at the council table. I'm sorry. Yes, ma'am.
Juror number 3, Kareem Setkinger. In the city, I don't know Detective Rudolph personally, but I do work for the St. Louis Metropolitan Police Department. I have heard of him.
Okay, from the jury list, it indicates that you are a systems analyst with the St. Louis City Police.
Correct.
Do you interact with police officers on a daily basis?
Yes.
Have you ever had any interactions with Detective Rudolph?
I don't remember. I don't see the faces. It's usually email or phone.
Okay, so other than just seeing his name, you do not have any other information about Detective Rudolph?
No.
Is there anything about your position as a systems analyst with the City of St. Louis Police that would affect your ability to be fair and an impartial juror in this case?
No.
So again, you can set aside, listen to the evidence and weigh it fairly and impartially?
Correct.
Okay, all right. Thank you very much. Anybody else know anybody at the council table to my right? Let me go to the council table to my left. It is Council Michael Leonard and Council Gloria Rodriguez. They represent Mr. Norman.
Good morning.
Thank you, Mr. Norman. If you would please raise as well. And this time, James Timothy Norman. Thank you, sir. Do any of you believe that you know any of the people that I have just introduced you to at the other council table? And I'll start here in the jury box. Any of you believe that you know of any of the people that I have introduced at the other council table? Yes, ma'am. Is that Miss Drummer? Is that correct?
I used to look at the television show.
Okay, and I'm going to ask you about that later on. But let me just ask you this, Miss Drummer. Have you ever interacted personally with Mr. Norman?
No.
So you have never met him, talked to him in person? And that answer is no. Is that correct?
Yes.
Okay, I'm going to ask you about the other matter. We will get to that shortly.
Okay.
Again, anybody else in the jury box believe that you know any of the people I have introduced at the other council table? I see no hands. The pews to my left, anybody believe that you know any of the people at that I've just introduced you to? And the pews in the middle, anyone believe that you know any of the people I have just introduced you to? Yes, ma'am, Miss Dong.
I don't know him, but I saw him on the television show.
Didn't I just say I'll get to that later? No. Nah, he didn't say that, y'all. That's me breaking script. Okay, Miss Dong, and I'm going to get to that. So I need you to answer in just a few minutes, but let me ask you again, Miss Dong, have you ever met Mr. Norman personally? Had any personal interactions with him?
I heard he fried some good chicken. No.
Thank you. Anybody else in the center pews? Then let me go to the pews to my right. Anybody else believe that you know any of the people I have just introduced? I see no hands. The chairs, anybody know any of the people that I just introduced? Okay. I'll take it by your silence and lack of hands that none of you do. I do not need to find out whether or not any of you have heard about the case. The parties have agreed to me reading the statement to you. The defendant in this case, James Timothy Norman, who goes by Tim, is charged with life insurance fraud conspiracy to commit murder for hire, as well as murder for hire in connection with the murder of Mr. Norman's nephew, Andre Montgomery, which occurred on March 14th, 2016 in the 3900 block of Natural Bridge. Mr. Norman has pled not guilty to all charges. Mr. Norman and Mr. Montgomery both appeared on a television show called Welcome to Sweetie Pies. that was broadcast between 2011 and 2018. So right now, what I would ask of you is whether or not any of you have heard about the case. I'm going to come back and ask you whether or not you have seen or heard about the television show. But right now, I just need to know about whether or not you have actually heard anything about the case. So I want to start here in the pews. And if you can raise your hand if you've heard about the case. And I see Miss Hall, Miss Seekinger, Miss Drummer, Miss Becker, and then go to it is Miss Stoff, Miss Hodge, and Mr. Whitley. Whiteley.
Whitley.
Mr. Whitley, okay, so all of you have indicated that you've heard something about the case. Sometimes people tell me they've heard something about a case. They know no details. They have just heard something. What I need to know is, of those of you who have raised your hand, anybody know any details about the case? And if you have raised your hand, I see no hands. So those of you who have indicated that you heard about the case, you know no details about it. My next question is, those of you who have indicated that you have heard something about the case, is there anything that you have heard that you can't set aside to be a fair and impartial jury in this case? And based on your decision solely, and base your decision solely on what you hear in this courtroom. Anybody unable to do that? I see no hands. So I want to come over here to the pews to my left. I want to ask again, with regards to the case, I want to see any hands of anyone who has heard anything about the case. And I'm going to have to ask you to identify yourself. So if you don't mind standing.
Juror number 19, Mary Peters.
Thank you, Miss Peters.
Juror number 30, Carrie Simpson.
Thank you, sir.
Juror number 41, Michelle Beck.
Thank you. And was there any other hands in the pews to my left? Those of you who have heard something about the case, I wanted to ask if you have heard anything, any details about the case.
No.
It was a group of them that said no. Okay. Is there anything that you have heard that you can't set aside and listen to the evidence in this case and weigh it fairly and impartially and disregard anything that you may have heard about this case? Is there anyone who can't do that?
I
can. Okay. And all three members in that group have affirmed that they can set aside anything that they may have heard, decide the case based solely upon the evidence that they hear in this courtroom. Let me go here to the pews in the middle, and there are a number of hands, and I want to start here in the first row to the far left. And again, if you will identify yourself by name, number.
Juror 20, Jamie Townsend.
Thank you very much. You can be seated, Miss Dong.
Kimberly Dong, Juror 21.
Thank you.
Juror number 23, Carmen White.
Thank you.
Juror number 24, Zachary Bond.
And then the second row.
Number 35, Molly Robinson.
And then the third row.
Juror number 44, Kelsey Necker.
And then
juror number 46, Nathan Shelf.
Thank you. Anybody else in the middle set of pews heard anything about the case? My next question is, have you heard any details about the case? Anybody heard details about the case?
No.
Is there anyone who can't set aside whatever they may have heard, listen to the evidence in this case, weigh it fairly and impartially based solely on the evidence you hear in this courtroom?
I can.
Okay, all of the panel members who have indicated that they heard about the case have affirmed that they can base their decision solely on the evidence in the courtroom. Anybody have any problem with that? Oh, okay. Let me go here to the pews to my right. I need to identify those of you who may have heard about the case. Let me qualify a little bit as I'm thinking about this. I know there are different ways that we get the news these days. You can get it on television, in newspapers, the internet, on blogs, websites. I'm asking you about any form of information you may have heard about this case. So I just want to make sure that doesn't modify anybody's questions that you have answered before. Does that affect anyone's answer that they gave before? I see no hands. So let me go back over to the pews to my right. Let me start in the first row. Yes, ma'am.
Juror number 27, Young Cloud.
Thank you very much. And then the second row.
Lamarche, number 39, Glenn Lamarche.
Thank you, sir. And
Schultz, juror 37, Doug Schultz. Juror 51, Viola Ritz McLeod.
thank you. Anybody else in that set of pews? Okay, those of you in the pews to my far right, is there anyone who knows any details about the case? I see no hands. Those of you in the pews to my right, have you heard something? Is there anyone who can't set aside what you have heard based on your decision, in this case, solely upon the evidence and the testimony that you hear in the courtroom, and be a fair juror to both sides of this case? Anybody have any problems with that? I see no hands. Let me come here to the chairs. Anybody heard about the case? Yes.
Juror 57, Brian Pennington.
Yes, sir, Mr. Pennington. Thank you. Anybody else in the chairs? Mr. Pennington, have you heard any details about the case?
No, sir.
Anything that you have heard, you can't set aside and listen to the evidence in this case, only the evidence in the courtroom, and weigh it fairly and impartially?
Yes, sir.
You can do that. Is that correct?
Yes, sir.
So again, you can set aside anything you may have heard.
Yes, sir.
All right. Again, if this is a very important question, ladies and gentlemen, I just want to make sure everyone in the courtroom that may have heard about this case either thought or either through word of mouth, television, news media, and no one has indicated that they have heard any details about the case. But I want to make sure that you search your memories. It's very important that you answer this question carefully and honestly. If there's anyone who has heard something about this case that would somehow affect your decision in this case, anybody, and I take it by your silence and lack of hands that all of you can follow the law based on your decision solely upon the evidence that you hear in this courtroom. The other question is that I want to ask you is if you have seen the show Welcome to Sweetie Pies. I know a couple of people have already indicated that they have. Miss Drummer, I know you indicated that you have. Can I just see the hands of those in the jury box who saw the show? Okay, it looks like Miss Drummer, you are the only person in the group. Again, the fact that you saw the show, again, the statement indicated different times for Mr. Norman's appearance. Mr. Norman appeared. Mr. Montgomery also appeared. Anything about you seeing the show that would affect your ability to be fair and impartial, juror?
No.
Thank you very much. Let me come here to the pews. Anybody who saw the show, can you raise your hands? I'm assuming you may have heard about it from other sources and other ways. But again, none of you in the pews to my left actually saw the show Welcome to Sweetie Pies. Thank you very much. So let me add to this a little commentary. Who that talking about something guilty? Bad Bunny. We ain't got to that part yet. But the makeup of the jury was primarily others. Like it wasn't black and browns. It was the others. So yeah, that would be why the majority of them hadn't seen it. And if I'm thinking of the same lady, and we'll know as we get further down, If I'm thinking of the same lady, the one who's saying she did see it, she was a black lady. And later, if she's the same person I'm thinking of, because she was over by the jury side.
They got rid of her?
They got rid of her, but she also said when she was crossed by Tim's attorney, he asked her, what do you remember? So you watched him on the show. What do you remember about him on the show? She said, his attitude. When she said that, I was like, you wasn't supposed to say, because she was saying she could be impartial. But the one thing she said she remembered about him was that his attitude. His attorney was like, you know too much of the real. You got to go. Okay, so it says in the middle, Judge Ross is saying, the pews in the middle, anybody actually see the show? Welcome to Sweetie Pies, Miss Dung. Yes, ma'am, if you don't mind.
Yes, I was going to say I watched like 3 or 4 episodes.
I do remember this part.
Miss Robbie sued him. No, I'm just
right. Okay, anything about that would affect your ability to be fair in an impartial jury in this case?
No, sir.
Thank you very much. Yes, sir.
Zachary Bond, number 24.
Okay, and there were a couple of yes, ma'am.
Molly Robinson, number 35. I watched that show and some clips.
Okay, again, anything about the clips that you saw? And I'll ask you also, sir, anything about what you saw affect your ability to be a fair and impartial jury?
No.
Okay, anybody else see the show in the middle pews? I see no hands. The pews to my right, anybody else actually see the show? And yes, in the second row, sir.
39, Glenn Lamarche. I didn't really watch it. I know about it in the context of the channel and what they're trying to do, and also in the historical context of this case.
Okay, when you say historical?
It's more of an example of, to be honest, of how this whole case came about in TV.
Okay, when you say in context of this case, what?
Just in the news and, how this case came about,
I remember this, y'all. This bringing back memories because I was like, what? And all of us was like, what are you saying, sir? What are you saying?
Try to sound
judge. All of us was confused. What do you say in the context of what? So Judge Ross says, okay, let me ask you about all of that. See, you can see, because he didn't do that with everybody else. He's like, okay, let me ask you about all that. Is there anything that you saw or heard that would affect your ability to be fair and impartial juror in this case?
No, sir.
So are you telling me that you can set aside anything you saw and heard, set aside your opinion about the show or all that, and be fair and impartial juror in this case?
Yes, sir.
The lies you tell. Okay, you can base, so Judge Ross goes on to say, you can base your decision in the case solely on the evidence and witnesses that you hear in this courtroom and not something you've heard outside the courtroom. Is that correct?
Yes, sir.
Okay, thank you very much. And then there was a hand in the back. Yes, ma'am. Now, we all knew that dude was out. We knew it in the moment. We were like, we don't see him no more. He out of here.
Yes.
I'm out in the context of you watching and pertinence to the show. What? You don't get out of here. You've been researching. That's what that said. You've been researching.
Yeah, I know he told himself.
Right. And then talking about you're going to be impartial. What?
Yes, 51.
Yes, ma'am.
I've seen the show. I've watched it.
And anything about you watching the show that would affect your ability to be fair and impartial jury in this case?
No, sir.
You can set aside anything you saw on the show, anything you've heard about the case?
Yes, sir.
Based on your decision solely, you can base your decision solely on the evidence and witnesses that you hear in this courtroom?
Yes, sir.
Thank you very much. Anybody else in the pews to my right and the chairs here? Anybody actually see the show?
I've seen it, but I never really watched it.
I've seen it, but I didn't watch it. Okay. Perhaps you saw clips of it, or?
No, my wife had it on. I just saw it.
Okay. Anything about the show itself, your wife's knowledge of it that would affect your ability to be a fair and impartial jury in this case?
No, sir.
Thank you very much. And Mr. Pendleton, just mentioning something about his wife, and it makes me want to ask sort of a follow-up question, not necessarily to you, Mr. Pendleton, but to all of you. To the extent that you have close family members or friends who may have watched the show, may have had information about the show, would that in any way affect anyone's ability to be a fair and impartial jury in this case? And I see no hands, so I'll take it to your silence that it would not affect any of you in this case. I want to go on to some general questions. I want to ask about whether or not any of you yourselves or close family members or friends have any legal background or training. Let me just start here in the pews. I'm sorry, in the jury box. Anybody with any legal background or training themselves or a close family member or friend? Yes, ma'am, Miss Hall.
My daughter-in-law is a paralegal at Brown and Crouppen. She has been there 20 years.
Okay, they generally do civil work. Has she ever been involved in criminal work?
No.
Anything about her work that would affect your ability to be fair in this case?
No.
Thank you very much, Miss Drummer.
My grandson was a lawyer in the city hall and he quit.
Okay, and is he still practicing law?
He is in Kansas City.
Okay, does he do civil work or criminal work, or do you know?
I don't know.
Okay, do you ever talk to him about cases he handles?
No, I don't.
Okay, anything about your knowledge of him and what he does that would affect your ability to be a fair juror in this case?
No.
Okay, all right. Yes, Miss Beckerly.
My daughter-in-law is an attorney for Armstrong Tisdale, and she does real estate law.
Okay, anything about her work that would affect your ability to be fair in this case?
No.
Thank you very much. Yes, sir.
My nephew is a defense attorney.
And what's his name by chance?
Nick Henderson.
Okay, do you ever talk to him about his cases or what he does?
I only see him about once a year.
Okay. Anything about your relationship with him? Anything that he may have told you that would affect your ability to be fair?
No.
Thank you very much, Mr. Gallagher. The back row. Okay, let me go here to the pews to my left. Anybody themselves or a close member or family friend with a legal background or training? Yes, sir.
Juror 17, Jeffrey Beller. My aunt and uncle were, I don't know. Are you looking for a law enforcement officers as well, or?
I'm going to come back and ask about law enforcement background training. Right now, I'm just asking about legal background training.
Oh, no.
Okay, thank you. And yes, there is a hand in the third row. Ma'am?
I'm a paralegal. I'm not working as a paralegal right now. Most of what I've done was in collections, business to business.
Anything about your experience in that regard that would affect your ability to be fair?
No.
Did you go to take classes to be a paralegal?
I did.
I don't know whether or not you took any criminal law.
I did.
To the extent that you had any classes in criminal law?
Just one general. I mean, it was all bunched into one.
Can you set aside anything you may have learned or think you learned?
Right.
And be guided by the instructions of the law as given in court?
Yes, sir. That was many years ago.
Okay, thank you very much. Anybody else in the pews to my left and the pews in the middle? Anybody with legal background or training? Yes, ma'am.
Juror 23, Carmen White. I'm not an attorney, but I currently work as a corporate law firm.
Okay, and you are at Greenfelder?
Yes, sir.
And you are the Director of Diversity and Community Relations. Is that correct?
That's correct.
But you don't have legal background or training.
No, I mean, I don't, but I have a lot of colleagues that are attorneys, and some have been public defenders. That's about it.
Okay. Have you ever talked to them about their cases, what they did?
Well, a little bit. It was several years ago.
Anything about anything that may have told you or your relationship with them that would affect your ability to be fair in this case?
No, sir.
I thank you very much. Thank you. There was another hand. Yes, sir.
Juror number 45, Harold Guest.
Yes, sir.
I know about a dozen of attorneys.
Do you know if any of them do criminal work?
I know one who does criminal work.
And who is that?
Joel Schwartz.
Okay, and Joel has certainly been in the news frequently lately on that other case. Do you talk about the other case with him?
I don't talk about cases with Joel.
Yeah. Anything about your relationship with Mr. Schwartz that would affect your ability to be fair in this case?
None whatsoever.
Okay, again, you can set that relationship and just listen to the evidence and weigh fairly and impartially?
Yes.
Thank you very much, Mr. Gast. Anybody else in the middle pews and the pews to my right, anybody themselves, close family members or friends with legal background or training? Second row, yes, sir.
Well, a number of years ago, I was...
Can you just stand? I'm sorry.
I'm sorry, number 39, Glenn LaMarche.
Yes, sir.
I worked in the state of Florida in the legislative and legal affairs for about 7 years in the late 90s, late 80s, mid 90s. It's been a long time. I also have a master's in criminology that I really used. I did for quite a while before I moved here.
Okay, so my question is, can you set aside anything you know or think you know about criminal law and follow all the instructions of the law as given by this court? Hell no.
Yes, sir.
Get out of here. So again, you can set aside, be a fair and impartial juror in this case?
Yes, sir.
Anything about your background and training that would affect you in this case?
It's a very hard question because a lot of education, a lot of training, a lot of years. But I'm ready to do my duty to this court, sir.
Didn't you just say you had nothing that was getting in the way of you being impartial, and then you're going to add all this? Make up your mind. Make up your mind. So Judge Ross goes on to say, and obviously I truly appreciate that. I'm sure, as I'm sure the parties do. What I need to ask of you is, to the best of your ability, can you set aside that background and training to this extent? The court, I'm going to instruct you on the law to be applied to the case. If it is different from what you understand the law to be, or what you believe the law to be, can you disregard what your thought or belief and follow the law as given by the court?
For sure. Yes, sir.
Okay, so can you tell me that you can do that?
Yes, sir.
Okay, thank you very much. Anybody else in the pews? Yes, sir.
Number 49, Mark Ennis Fitch. I probably slaughtered his name. My cousin is a lawyer.
Do you know, does he do criminal work or civil work?
I think it's mostly civil.
Have you ever talked to him about the cases he handles?
No.
Anything about the relationship that would affect your ability to be fair in this case?
No, sir.
And thank you very much. Anybody else have? I'm sorry. I need to go to the chairs. Anybody in the chairs with legal background or training themselves or close family members or friends? Okay, Mr. Baylor, I brought up the issue of law enforcement background and training. Mr. Barmerito.
Yes, sir.
I think we know your background and training.
Yes, sir.
But let me ask about anybody else, to the extent that you yourself or close family members has law enforcement background or training. Let me start here in the jury box. Yes, Miss Seckler.
I work at a police department.
And I ask you this again. I anticipate that you are going to hear testimony from police officers, law enforcement. My question of you is, can you set aside any good or bad that you may know about police officers and listen to their testimony and weigh it fairly and impartially?
Yes, sir.
So there is anything about your work and its systems analyst, as a system analyst at the police department, that would affect your ability to be fair in this case?
No.
Thank you very much, Mrs. Drummer. Did you have an answer? Yes, ma'am.
My daughter is a correctional officer.
And is she a correctional officer?
In the city.
In the city.
City of St. Louis.
Okay. And how long has she been doing that?
About 15 years.
And I'm sure she talks to you about different things.
We work different shifts, so I really don't talk to her.
Okay. All right. And when you first said different shifts, I was wondering, do you work there?
No, I work in the evening and she works in the daytime.
Okay. So you don't talk to her about that?
No.
Is there anything about your relationship with her, your knowledge of her, or anything that she may have told you about her experiences that would affect your ability to be fair in this case?
No.
Okay, so again, you can set all of that aside?
Yes.
Thank you very much, Ms. Drummer. Yes, sir. Mr. Curtis?
I worked 26 years for the Department of Corrections state.
And for the state of Missouri?
Right.
Obviously, during that time, you heard and saw a lot. I guess my question of you is, can you set aside those experiences and just listen to the evidence in the case, weigh it fairly and impartially?
Yes, sir.
Anything about your work in that regard that would affect your ability to weigh the evidence? Again, you are going to hear from law enforcement officers. You are going to hear from a number of different witnesses. It is very important that the jurors, that you are able to weigh the testimony fairly and impartially. And you are telling me that you can do that? Is that correct, sir?
Yes, sir.
Any questions about that?
No, sir.
Thank you very much, Mr. Curtis. Yes, ma'am. Miss Berkeley?
My son was a City of St. Louis police officer for 3 years, from 2011 to 2014.
And where was he a police officer?
St. Louis, the city of St. Louis.
Did you? I wasn't listening, but did you ever talk to him about what he did or his duties? What his duties were?
Sometimes with tea and crumpets. No, sometimes.
Anything about your relationship with him? Your knowledge of what he did? Anything about what that would? Anything about that would affect your ability to be fair and impartial juror in this case?
No.
Ms. Beckerly, again, it is important that you understand that you're going to hear testimony from law enforcement officers, and it is important that the jury weigh their testimony fairly and impartially. So I need to ask you, can you set aside your knowledge of what he did and what he may have told you and listen to their testimony and weigh it just as you would any other witness?
Absolutely.
Thank you very much. Anybody else, ma'am?
Number 9, Melody Tulusky. My stepdad is a correction officer in Pacific. He doesn't really talk about work, but.
And is he a corrections officer at the facility there in Pacific?
Yes.
Okay, and that's a state facility. Anything about your relationship with him, your knowledge of what he does, anything that he may have told you that would affect your ability to be fair in this case?
No, he doesn't talk about work with me.
Okay, well, thank you very much, Mrs. Gallagher. Mr. Gallagher, yes, sir.
I have 3 members of my wife's family that are involved in law enforcement. Someone who's a police officer with St. Louis County, someone who's a correctional officer in the Pacific, and the other is a bailiff in St. Louis County.
Do you ever talk to them about details of what they do?
No.
Lies. Anything about your knowledge of them? Anything that may have told you that would affect your that they would have told you that would affect your ability to be a fair and impartial juror in this case?
No.
Thank you very much, Mr. Gallagher. And then in the back row, yes, ma'am.
Number 13.
I know the officer.
Oh,
I'm sorry. Yes, ma'am. Yes, ma'am.
I
No, you're
know
right.
an officer. He works.
You're lying.
Oh, I know an officer. He works for St. Charles County Police.
And in getting to know him, did you talk to him about what he did in his duties?
A little bit.
Is there anything that he may have told you or your knowledge of him that would affect your ability to be fair and impartial a juror in this case?
No.
So you can set aside and listen to the evidence and weigh it fairly and impartially?
Yes.
Okay, again, tell me where he is working now.
St. Charles County.
Okay, and again, as I have said to others, will you hear the testimony from law? You will hear testimony from law enforcement officers. It is important as a juror that you're able to weigh that fairly and impartially. Your knowledge of him, would that cause you to give greater weight to a police officer's testimony?
No.
Yes. She said no, y'all. So again, are you telling me that you can set aside and be fair and impartial juror in this case, correct?
That's correct. Do these people listen to other jurors?
Not really, obviously.
I can tell.
Okay. Everybody, people were falling asleep. Somebody, I think, we should get to that. Somebody got reprimanded because they was.
I know. Yeah, I read that.
Yeah. Okay. Then, and then a couple of other hands, Mr. Whiteley.
I have some minor contact with the police department through my work.
You work for the city of St. Louis, is that correct?
Yes, that's correct.
In your contact with some of the police officers, do you talk about what they do?
Primarily with IT, if they come to us.
All right. Anything about your experience, your knowledge of them, your position with the city of St. Louis that would affect your ability to be fair in this case?
I'm a computer nerd. No, he didn't say that. No, sir.
Okay. Thank you very much. Yes, ma'am. It is Miss Martin.
Correct. I occasionally work with police officers for my job as security for events.
And okay, so you work at a pageant, is that correct?
Correct.
John Benet Ramsey, did you know her? No. And I'm sure they do have security. So you work with them in that context, is that right?
Correct. We don't talk about their work outside of that situation.
Anything about your dealings with them, your knowledge of them that would affect your ability to be fair in this case?
No, sir.
Thank you very much. So let me go here to Mr. Baylor. I know you have already told us that you have relatives.
Yes, an aunt and uncle who were longtime St. Louis County police officers. And my aunt's second husband is I think it's is an FBI agent. I'm not exactly sure. You know why you're not sure? Because look how you running your mouth.
Mm-hmm.
Didn't say that.
Okay, let me ask you about both of them. Have you talked to them about their duties and responsibilities?
Well, yes.
Is there anything they have told you or the relationship with them that would affect your ability to be fair and impartial juror in this case?
No, sir.
So again, you are telling me that you can set that aside?
Yes.
Listen to the evidence and weigh it fairly and impartially?
Yes, sir.
Okay, thank you very much. Anybody else?
Juror number 18. My husband is a special agent for the FDA in law enforcement.
There's a lot of law enforcement related people in this crowd. Nobody's seen the show, but everybody in law enforcement. Okay, his duties and responsibilities is different than probably witness that you may hear in the courtroom. But is there anything he has told you or your knowledge of what he does in relationship that would affect your ability to be fair and impartial juror in this case?
No, it's super boring. So no.
That's super boring. Okay, that's good analysis of it. Again, you are going to hear from law enforcement officers as witnesses in this case, I anticipate. Is there anything about the relationship that would affect your ability to weigh in their testimony as you would any other witness?
No, he was only a police officer for a very long time for St. Peter's as well.
Okay, and again,
Nothing
that he has told you, the relationship with him, would that in any way affect your ability to be fair and impartial juror? Is that correct?
No, sir.
Okay, thank you very much, Miss Turbrock. Yes, ma'am.
Number 19, Mary Peters.
Yes. No. Yes. Okay, that's me. Yes.
My brother, he is no longer a police officer. But he did work for St. Louis County in Pine Law and Evanston's.
Okay. Do you remember the years that he would have?
I don't really remember the years. He is 72 and in a nursing home right now. I know in his younger years, he worked for St. Louis County, maybe 25 or 26 years before he got hit on the highway. So he went to other departments.
Anything about your knowledge of him? Anything that he may have told you that would affect your ability to be?
No, he never discussed his business with us.
Okay, so you can be fair and an impartial juror?
Yes.
Thank you very much. And yes, Mr. Thiessen?
Yeah, juror number 30, Carrot Thiessen. I have a nephew who's a correction officer in Jefferson City. I also have a neighbor who's a security officer at the National Geospatial Agency. I worked for the Boeing Company for many years as a corporate investigator and took police interrogation training during the time.
Anything about your knowledge of those people, your background and training that would affect your ability to be a fair juror?
I don't think it would affect my ability to be fair, but my training and background would cause me to use that to determine credibility of the witnesses and the evidence that appeared in court.
So in other words, you don't want to be here.
Basically.
I mean, I will say to you, and I'll say to all of you, that we are not asking you to leave your backgrounds outside of the courtroom, but it is important that you weigh the testimony fairly and impartially. I understand your position, Mr. Thiessen, and honestly, just based on your father's situation, you don't need to answer any more questions. Oh, this is the same guy, y'all.
Yes.
Just count that. So thank you very much. He landed on thick.
Yes.
He like on top. Okay, I got a relative that's real sick, and if you ain't gonna take that,
I'm gonna tell you this.
I'm gonna be impartial.
Yes, I'm being partial now.
So thank you very much. There was another hand over to my left. Yes, ma'am. He like Judge Ross, like, don't worry about coming up with more. You good. We gonna live
Juror 28, Carolyn Martin.
Yes, ma'am.
My daughter was a correctional officer, and my son is now a correctional officer.
Anything about your knowledge of what they do and that they may have told you that would affect your ability to be a fair and impartial juror in this case?
No.
So again, you can set that aside?
Yes.
Okay, thank you very much. And Mr. Burrito, again, we're aware of your background and training of all that. So I think you have covered that question. Thank you.
He trying to leave.
Right.
Thank you. Yes.
Anybody else in the pews? Yes, sir. Back over here.
Juror 53. My brother-in-law is currently a correction officer at a facility. My nephew was a highway patrolman for 4 years and now a federal officer at Jefferson Barracks.
When you say federal officer, is he a federal security officer of some kind?
Yeah.
Okay. All right. Anything about that, Mr. Laham, that would affect your ability to be fair and impartial in this case?
No.
I'll ask you again what I have asked a number of people. I anticipate that you're going to hear from law enforcement. Can you set that aside and listen to the testimony and weigh in fair and impartially?
Yes, sir.
Thank you very much. And Mr. Robertson, Mrs. Robertson, again, I know your husband is a police officer. Again, what I want to ask you is if you hear from other law enforcement, can you weigh their testimony just as you would any other witness that comes in here to court?
Yes, sir. They want to get off of jury duty. They were trying to get out of that.
Right. So again, can you set aside that relationship to be fair and impartial?
Oh, yes, sir.
Anything about your relationship, your husband's job duties, or anything that could affect your ability to be fair in this case?
No.
Thank you very much. Let me go here to the pews in the middle. And I'm breaking script for a minute. So I was trying to end this at 2 hours on the dot.
Yes.
But then I'm trying to make it where part 2, we just get this done. It looked like we good, though. Let me see. How many more? So that was 71. Oh, Jesus.
Yeah, we got a lot to do.
Okay, so what I'm going to do between today and tomorrow, I'm going to scrub through this and just highlight the meat of it.
Yes.
I'm gonna have to do that with the rest of it. So as we see, you get the feel for it. There'll be a couple meatier things coming from the jury. So I'll just highlight those pieces, and then we'll move on into testimony, and that's where it'll get to I didn't do it, which is I know what most of y'all are looking forward to. So at this point, let me remember where we left off at. I just scrolled myself away from it. Okay, so so yeah, we will resume on tomorrow evening, 7:15 Central, 8:15 Eastern. And again, if you are interested in volunteering to be an understudy or anything for here it is. Understudy or anything for our reading, our roles, because again, we're gonna be doing this for another week or two.
I can't do all the voices, people. I tried.
Yes, and thank you so much to our cast for this evening. We had Precious G, Carol C, and Robert. We thank you all for your hard work today. You're greatly appreciated by myself and the VPO community. And I think that's it. With that, I'm gonna close y'all out with a trailer. And remember, I put those links in below if you haven't seen the plot timeline for this whole case that we're doing. It lays out everything that happened. We're going to be going over the transcripts, but if you watch that, it'll tie things together for you. And then also part 2 of the Michelle Griggs interview, if you haven't seen that. I'm going to also link them below in the chat. So yeah, in the pinned comments and in the description area of this video below. But with that, I thank all of you for joining us this evening. And until next time, make sure to take care and be blessed.
They came back last time from St. So when Dre came back the last time from being in St. Louis, he wasn't living with Robbie at the time. He came back and he said, "Mom," he said, "if anything ever happened to me, just know that Tim did it." "What are you talking about?" He said, "Well, just know Tim don't never do his own dirty work." But I got that fatal call from her about Dre, and I didn't want to answer the phone. You know, I just didn't want to answer the phone. And then she hung up and she called right back. And then that's when she was like, "Well, you know, the detectives was here." And already my heart is already slowing down, you know, and to the point where they want her to go down to the morgue to identify that was him. That was it. You know, it was like, it was so surreal. Everything just rolling around. I'm just like, not my son. You know, not my son. Not my son.